of the state can no longer be carried on in accordance with the provisions of the Constitution. In fact, it's now become a musical line. And governors who are sworn in are very familiar with this line, and particularly if it is a government which belongs to a political party than the one which sent them to be appointed as governors, they feel that the line has greater meaning. Now, consider any number of cases. Did the draftsmen of the Constitution believe that in a period of 60 years, we actually would have a very impressive tally of presidential rule? 124. And do we believe that 124 times governance of the state could not be carried on in accordance with the provisions of the Constitution? And is democratically elected government meant to be so fragile that it falls, it can be manipulated, and governors are very ready to give a report that the state will not be able to tolerate a democratically elected government? I'm concerned, and I'm going to raise this point before you, that if you look at it, thank you, in terms of political justice, if you look at this in terms of fraternity, if you look at it in terms of democracy, if you look at it in terms of equality, if you look at it in terms of liberty, every mana fide exercise of power under Article 356 directly hits all these cardinal concepts. It is utterly undemocratic. It is utterly a violation of the rule of law in the Constitution. It directly impinges upon the aspirations of people who are entitled to social, economic, and political justice. And it is indeed now a very powerful tool of, shall we say, political manipulation. So Article 356 has become relevant in the context of what we see as contemporary political phenomena. The political phenomena of engineering a split in a political party. You suddenly find that legislators forgot that they belong to one political party. They are struck by conscientious disturbances in the night, and the next morning they want to split from the political party on which ticket they came to power. And manipulations take place, as a result of which you have sometimes a very comical sight that the incumbent chief minister has to parade all the people who are supposed to be supporting him before the governor. And the governor sits in a chair and he sees this parade. He sees the chief minister, or the man who is claiming that he has so many legislators behind him, walking right in front of him. Now, is this relevant for the purpose of Article 356? It has become relevant because today, the possibility of misuse of 356, or the availability of 356, has added a new complexion in our political processes by which people can quickly determine various manipulative components in the body politic and bring about a situation which takes you to the brink of Article 356. Now, Article 356 was never intended to be used as a political tool at all. It was intended to be used where you cannot have a democratically elected government which is collectively responsible to a house or a legislature which will be able to carry on administration of the state. And it was necessary that you had to go back to the people to see their verdict, their political judgment. But it was never intended that those who were elected would actually have to defend themselves in a court of law against an unjust imposition of Article 356 and wait for a judgment of a court that they would either be appointed as a chief minister, or they could continue as a chief minister, or they could finish their incomplete business as chief minister. But I'm afraid for the last few years, we have been observing that there has been a misuse of Article 356. During the period of one Prime Minister, 50 instances of President's rule can be counted during that person's tenure, multiple tenures as a Prime Minister. 50. 50. Not a small number. And some states seem to be more privy to President's rule. I wonder whether the Constitution loves Manipur more. Does it love people in the northeastern states more? It definitely likes Uttarakhand, clearly. Uttarakhand, Bihar, they are very, very 356 friendly. But why does this happen? And this absolute aggrandizement for power in breach of the Constitution is indeed the main topic which we need to address when we look at the use and abuse of Article 356. It is one thing that a court gives a declaration about the invalidity of the exercise of power under Article 356. It did so in Rameshwar Prasad. And if you were to frankly ask me, I think, notwithstanding the encomiums which have been paid to the judgment and state of Rajasthan, I think Charan Singh's act of dissolution of all those assemblies was completely unconstitutional. Nobody can simply say, I am gauging the mood of people, and people are talking differently. And there is actually, it's important to have a public sentiment in mind. And he simply wrote a letter to the Chief Minister of Rajasthan saying, dear Mr. Joshi, you know, a recent electoral verdict has shown the true will of the people, and it's time that you simply quit. And mind you, is that a ground for the purpose of exercise of Article 356? Is it a ground to say that the winds are blowing in one direction? It's quite likely that the winds may blow here in another direction, but then why not have elections every week? The winds will blow differently. This is completely a mockery of democracy. The ability to stand by a commitment to the Constitution and not to displace democratically elected governments requires courage. It first of all requires courage, not of a very extraordinary Herculean kind. It requires simple moral courage to understand what the Constitution says. In fact, I wish to tell you at one point of time, a very senior minister in government asked me, when I was Solicitor General, that is it not possible to exercise the powers under Article 355? And I said, I'm sorry, there's no power. It's meant to be your duty. And I simply cut short the conversation. But the keenness to look for power in every article of the Constitution is remarkable. So somebody said 356 is just not enough. Let's also look at 355 as an independent source of power for the purpose of justifying central action. Why not actually destabilize the police machinery in one state and send paramilitary troops from the central government who will act according to your command and send them into a state? And claim that it shall be the duty of the Union to observe that all states carry on their functions in accordance with the provisions of the Constitution. This is meant as a facilitative article where any central government is expected to support all state governments in ensuring that governance takes place in accordance with the Constitution. It is never meant for the purpose of overreaching elected state governments. Well, we are a federal state. Yes, we've had a great debate. Are we unitary? Are we federal? Are we quasi-federal? Are we an amphibian? Then we have referred to Casey, we are a federalist. But Bombay is a watershed to the extent it marked that federalism was indeed a basic feature of the Constitution. And federalism is vital for holding country together, but also for assuring people some autonomy. And autonomy does not mean you carve out more and more and more and more states. The need for a new state has largely been occasioned by the fact that people who belong to a particular region have been utterly neglected, have not received the benefits of any trickle-down of the economic concessions or economic conferments which are made by the center to the state, and felt that the only way that they could have any betterment or any say is again by a process of getting a position or recognition or cognizance through an instrument of power, which is you have a new state. Now imagine that we have Uttar Pradesh. Uttar Pradesh was one state, but today we have Uttarakhand. Uttarakhand is a new state. We had Bihar. You have Jharkhand, which is a new state. We didn't have Chhattisgarh. We had Madhya Pradesh. You have Chhattisgarh, which is a new state. But what is, and now of course you have Telangana, and you have Andhra, and you must have more capitals, and you must have more high courts, and if you have more high courts, you must have more judges. But the purpose is to deal with aspirations of people to have democratically elected governments to represent them, not be overshot by the power under Article 356. What is then the role of the governor? Well, the fact is, in today's world, we have to realistically reckon that the governor is a completely political appointee. And he is not looking at the Constitution. He is looking for messages and information, and he acts completely outside the Constitution. How does a governor ever make an intelligent appraisal based on intelligence reports about possible horse trading? How does he come to know about a possible horse trading? He has neither seen the horses, nor has he seen the trade, but he comes to a kind of a mythical conclusion about possible horse trading, and then decides, for the purity of democracy, it is important that those who can actually form a government must not be allowed to form the government. The floor test is supposed to be the best way to determine whether a person is able to command the confidence of a house. But prima facie, anybody who stakes a claim to be the chief minister must have demonstrable strength to be invited to form a government, or at least in any event, the person who is the leader of the largest party is asked to form a government. Either the person says, sorry, I cannot form a government, or he hopes that once he becomes a chief minister, there shall be miraculous splits, there can be defections, there can be any number of manipulations by which the arithmetic can be changed, and arithmetic has been changed. Uttarakhand is actually a neck-to-neck race. In fact, one wondered whether anybody was worried about the appropriation bill? Or was it that they were worried about who should become the chief minister, or whether there should be a presidential devolution as quickly as possible? Take the case of Arunachal Pradesh. Was there any reason at all for the governor to intervene? And the governor then becomes a very convenient instrument for a central government which is looking at it purely in terms of political strategy. Nowadays, just as you have legal strategists, political strategists are by the plenty in a political party. And in fact, political strategy means how well can you hoodwink the constitution? And how to hoodwink the constitution? Engineer false reports, create confusion, bring about a state of instability, create, if possible, absolutely questionable episodes of breakdown of law and order, and write a report. And on the basis of a report which is infirm, if a central government is determined that President's rule should be imposed, let me tell you, Governor's reports are not put in the dustbin. They are acted upon, and post haste there is a cabinet meeting, and immediately the President is tendered aid and advice. I am of the firm opinion that there is a need to revisit the theory of aid and advice insofar as Article 356 of the Constitution is concerned, in respect of dismantling of politically elected governments. It is one thing that where you have a law and order situation, or where you have a complete collapse of constitutional behavior and apparatus within a state, a president can be bound by the aid and advice of the Council of Ministers. But if it is a question where it is going to be subversive of the very principle of democracy, he must have some discretion. He's, after all, the last custodian of the Constitution. We cannot have any string of constitutional functionaries to say, "I'm so sorry, my hands are bound." And then we look at the possibility of judicial intervention. Take the case of Arunachal. In Arunachal, they had to direct the restoration of a status quo ante. And that's the first time the Supreme Court has done that. But it illustrates a point that time can overtake any legal intercession. By the time there is legal adjudication, much water may have flowed. It is entirely another matter that in Arunachal, you still had a status quo ante which could be restored. But very often, the status quo itself may be altered so irreversibly that nothing can be done. I think one of the important points to consider is that Bombay was a landmark decision, but even Bombay did not contemplate that there will be writ petitions galore to question imposition of President's rule. Now, the theory of examining the exercise of constitutional power is also well settled. Chief Justice Joseph, in the Uttarakhand judgment, is right when he says that as far as constitutional power is concerned, and that's a subtle point, it's not the mere absence of bona fides which is relevant. The presence of bona fides must also be established. It's a very valid point, and it is a subtle point, because the possibilities of colorably exercising constitutional power is very high. It is very easy to recite statutory and constitutional provisions as they are and claim immunity on the strength of the written word, on the text. Therefore, it is necessary, in my view, that when the imposition of a president's rule is challenged under Article 356, any government which seeks to defend it must be able to establish by taking recourse to consistent, rational parameters to be able to satisfy the court that the satisfaction, even though called subjective, was not really a subjective satisfaction. It was objective in character. I'm afraid that is the threshold which any challenge must meet in relation to imposition of a precedence rule. But look at another aspect in the Uttarakhand case. We had Chief Justice Joseph's judgment, but we also had a sequel to the judgment, and that is the 3 Supreme Court orders. And those orders, in my humble submission, all lawyers must know that is a very important phrase, humble submission, because it's a very protective gear, are completely erroneous. It is impossible to think that the court will appoint an officer to see how legislative business is conducted. Completely wrong. The integrity of a legislature is not meant to be assailed by the court appointing an overseer to find out how votes were cast. This was completely erroneous. It is one thing that the court wants to ensure that democracy prevails, but its interference could well have been to confirm the judgment or not confirm the judgment, interfere with the judgment. But we still had this play of an officer who did not belong to the legislature, an officer who belonged to the government, come in as a specially designated officer by the court into the premises of the legislature and give a report to the Supreme Court about the polling in a confidence motion. Completely unheard of. And I'm very sorry to tell you that democracy cannot be done in a court, and democracy cannot be undertaken by a court appointee or an observer who will come and give a report to the court about the number of people who voted in support of the confidence motion and the number of people who voted against it. And that becomes the basis of a revocation of a presidential proclamation. Well, all that it tells us is that the 356 jurisprudence is still very fresh. It tells us that there is still some more ground to cover. But when a high court, which is also a constitutional court and is entitled to the highest respect, has given a well-considered opinion on the validity of the imposition of Article 356 or the actions of a governor in attempting to interfere with an elected government, a court of appeal must take one view or the other. But the court of appeal cannot, in my view, start a new process of rediscovery. That is a great danger in Article 356. The integrity of a legislative proceeding and a vote which should be taken on the floor of a house has its sanctity. While I completely speak up for judicial independence, while I completely speak up for judicial activism, I certainly cannot see judiciary overseeing vote on the floor of a house. And it is an overreach, and it is not correct. But how has this happened? It has happened because of the enhanced amenability to judicial review because of numerous instances of abuse of power in relation to Article 356. Now, we have had the Sarkaria Commission, which has made recommendations about what kind of gentlemen have to be appointed as governors. Have we actually seen adherence to them? Then we've had another report by Chief Justice Punchi, for the study of center-state relations, who again used a lot of Sarkaria's material. It has come out in a slightly different form. What has happened to these recommendations? And I find that governors are able, by virtue of constitutional immunity under Article 361, completely unanswerable. They are not elected. They are governors, and they have done somebody's bidding, and they are ensconced. The president must have the inherent authority to recall the services of a governor who he thinks has not actually faithfully upheld the Constitution. Now you have an article like Article 78, when it says that the president is meant to be apprised about things which happen in the country. It's not meant to be simply an intimation article, an article of intimation to the president. It also means that the president is an active functionary in ensuring the observance of the spirit of the Constitution. Therefore, we must understand that the true crisis lies in relation to Article 356 in the context of the aspirations of people to be governed by those who have been democratically elected and who do not fall foul of the 10th schedule, who are not, shall we say, who are not stock legislators. We have had a number of people in this country who have actually changed their political parties more than once. They seem to have a regeneration of their political identity at repeated intervals. There is a lot of planning about the structure of a family, who should belong to which political party. These have all become matters of expediency. And the point which we need to consider is expediency the guide to the Constitution? Or does the Constitution contemplate or contraindicate that expediency is not meant to be its concern? When there is a collapse, it is meant to be the Constitution's concern, but nothing short of it. After all, people also have to see how well their elected representatives perform in the most trying situations. And unless you see their performance and assess their performance, how are you going to be able to incur a second political judgment in relation to those persons? I'm afraid that the freedom of expression in the legislature itself has been greatly diminished. I do not see in debates today that members of a political party question the ministers of their political party at all. They simply join the chorus of praising the ministers, but they don't question. They don't actually embark on any kind of critical appraisal in a debate. And the result is that democracy is already working with certain shrunk and constricted mechanisms. And 356 then becomes a lion's gate through which shrunk mechanisms can quickly fall. Therefore, if the true spirit of 356 has to be resuscitated, it is possible only by a vigilant civil society. It is possible only by a vigilant press. It is possible only when those who govern must really govern in accordance with the spirit of the Constitution. Now, I want to tell you something about the state of Rajasthan case. There is a passage in Chief Justice Beg's judgment which I think is extremely interesting. The passage says that there is no legal right under the Constitution for a state government to claim a certain period of time to be the period of time for which it should govern. I'm sorry, with respect to the learned Chief Justice, it is incorrect. Because the cornerstone of democracy is to be able to govern until you are displaced validly in accordance with the Constitution. Now, can anybody say, what is the nature of this right? It is not a right. It is actually the heart and soul of the Constitution. For anybody who is democratically elected must be able to govern is actually a fundamental tryst which he has with the will of the people, and it is meant to be fulfilled. And that cannot be obstructed on the ground that there is an absence of a legal right or a diminished legal right. Another learned judge took the view that, well, a chief minister and his ministers are not, strictly speaking, a state. They may be persons within a state, but they are not the state. Again, it is flawed, because the state government as an entity will have no meaning unless those who are meant to compose it and constitute it are not able to perform the functions of governance. One thing which you will notice in the judgments, and I'm not going into the judgments because most of you would have read both Chief Justice Joseph's judgment as well as the judgment of Justice Kehar in the Arunachal Pradesh case. One thing needs to be noted in both these judgments. In both these judgments, the judges are conscious of the separation of powers. They also realize that this theory that courts cannot substitute their belief, opinion, satisfaction for that of the satisfaction authority, and so on and so forth, is all very well. But when they actually see a violation of the Constitution by virtue of an oblique recourse to 356, the courts have to interfere, because it would otherwise be a diminution of the Constitution. And one must understand that it is not simply misjudgment. It is not simply a mala fide exercise of power which takes place when a wrongful exercise of Article 356 takes place. It is a lessening of the Constitution. And I'm sorry, we must not permit people to lessen the Constitution. The Constitution is not only supreme, but it has the most fundamental values for discernment and judgment. And it should never be compromised unless and until we come to the rescue of those who are humiliated. Actually, those who are humiliated are not the displaced chief minister and his council of ministers. Those who are humiliated are not some legislators. Those who are humiliated are the people who have undertaken the exercise in democracy. And if people's verdict means anything, that verdict needs to be respected. The processes by which people's verdict must be honored by way of a floor test is mandatory. And a floor test is indeed the surest way to determine whether a person enjoys the answerability and the confidence of the House. Unless and until these safeguards are made available in terms of our reflection over people's judgment or people's political choice, Article 356 will be only like a printed clause in a contract that anybody who becomes a legislator comma, if he does become a chief minister, comma, can be subjected to a manifold exercise of power under Article 356. Therefore, the canons of administrative law, such as relevant considerations, eschewing irrelevant considerations, acting upon true purpose, acting upon valid material, show enhanced parameters of accountability, and I'm afraid law must encourage it. Because the demands in our society, by virtue of the claims to justice, the claims to fraternity, the claims to equality, and the claims to democracy are so important that accountability in law must involve higher and higher and higher thresholds when you want to displace democracy. And if a government can satisfy the higher threshold, it passes muster. But if a government does not pass that threshold, it must pay for it. But the Constitution is not intended to be a residue of provisions which enable manipulation of people and their judgment. It is very necessary for us to protect our fellow citizens as a part of our duty in terms of fraternity, that their judgment must be respected strictly in accordance with the Constitution. The verdict of the people is really the essence of democracy. And however much we may campaign for electoral reforms, we may have our own views, but still it is at least some kind of process by which we have participation. And the participation of members of our society who are held together by an equality clause needs to be respected and honored. And we must not allow the constitutional articles to be interpreted in a manner that the fundamental goal of the Constitution itself is lost sight of. In my view, the fundamental goal of the Constitution is ultimately to respect the will of the people. But the will of the people also, even in a majoritarian verdict, can never ride roughshod over what all of you have learned are the guaranteed parts of human rights and other fundamental freedoms. But I'm afraid when you violate democracy, I believe that you also violate a fundamental freedom enjoyed by the citizens of the country. So I would like to stop here, and I have attempted to take a detour from what would be a classical exposition of Article 356, which means I tell you what each judge said. But I think it's important that we need to look at these issues somewhat collectively. And the purpose is to encourage a collective way of thinking on these issues because they are contemporary, they are relevant, and our country is undergoing a considerable degree of political churning, political activity, and the need to maintain the federal spirit is somewhat primary. And the need is not in terms of political party A and B, but I think the need is to respect people's judgment when they do elect people belonging to an alternate political party. So, thank you. And